Hello everybody, welcome to iExamB's Legal Bee. This is Amrita, your law faculty at iExamB. आज की इस वीडियो में हम लोग हमारी लॉ ऑफ टॉर्ट्स की मॉक टेस्ट सीरीज कंटिन्यू करेंगे एंड दिस इज वेरी बेनिफिशियल for exam preparation because in this not only your concepts get clear but also you have an idea of what kind of questions can come in the form of MCQs from such kind of theoretical subjects, completely principle and case law based subjects like law of torts. सो आप इन वीडियोस को मिस मत कीजिए. बाकी सब्जेक्ट्स के लिए भी ये वीडियोस ऑलरेडी ऑन गोइंग है सीरीज के फॉर्म में एवरी डे एट 11 AM एक्सक्लूसिवली ऑन लीगल बी. सो डोंट फॉरगेट टू सब्सक्राइब टू लीगल बी. And also, if you have any queries, you can write to us on hello@iexamb.com or in the comment section of this video. If you need questions on some topic, आप लोग mention कर सकते हैं. We will surely try to get back on it. So this is the second video from the series of Law of Torts important questions. Before I start with that, I will give you some updates about the UGC NET law examination to be conducted in June 2023. उससे related free mock tests available है at www.iexamb.com. So I would suggest everybody to attempt the mock tests. These are free mock tests and will help you strategize for your preparation. So if you have any queries, you can also reach out to us and don't miss it because strategy in cracking the examination is very important. So ये अपॉर्चुनिटी आपके पास है. मॉक टेस्ट को जाकर चेक कर लीजिए, अटेम्प्ट कर लीजिए एंड अपनी प्रेपरेशन को फेस कर लीजिए. अगर आपके और कोई भी क्वेरीज हैं रिलेटिंग टू इट, आप helpme@iexamb.com पे भी ईमेल कर सकते हैं या कॉल भी कर सकते हैं इस नंबर पर डायरेक्टली 9205524028. Also, we have law clerk interview guidance course that is still available at iExamB. The interviews have already started in the high court establishments at Bombay, Nagpur, Aurangabad. It is going to be conducted and is also started in some places. So mock interviews आपके कंडक्ट किए जाएंगे अगर आप इस कोर्स को लेते हैं तो. So you can also check the details of that as we help you prepare 50% faster at iExamB. First question. Which of the following tests determines that damage is remote or not? Test of reasonable foresight, test of directness, test of connectivity, test of farsightedness, both A and B, that is test of reasonable foresight and test of directness. Now this is a very knowledge based question. अगर आपको आता है तो ये आ जाता है एंड ये बहुत सिंपल कंसेप्ट है. एक बार आपने आज भी पढ़ लिया है अगर इस वीडियो में, आप भूलोगे नहीं इसे. एंड आई वुड सजेस्ट कि आप ये कंसेप्ट को हमेशा ध्यान में रख पाएंगे तो ये एक अच्छा आपके लिए नॉलेज बेस्ड वीडियो हो जाता है. सो यू कैन ऑल्सो डाउनलोड द PPTs of these videos and keep with you. So the correct answer for this question is E, that is both A and B. Test of reasonable foresight and test of directness. These are two concepts. And these are talking about the remoteness of damages. Everybody knows that in law of torts, damages is very, very important. So when you're calculating the damages, you have to see whether the damages are very much grave or whether they are remote from the cause of action. So that has to be a test. Test of reasonable foresight and test of directness are the prominent tests for it. To see that whether the consequences of the wrongful act were foreseeable, and if they were foreseeable, then the reasonable foresight test is satisfied. Whether the act was directly contributing to those damages, whether the damages were direct result of that act, then the test of directness is also satisfied. Second question. A defendant is liable to the consequences which are not dash from his conduct. Now, apologies that the answer is already available on the screen, but anyhow, we can actually check the question. The framing of this question is something which is important. The question is easy actually, but जैसे बीच में blank डाल दिया है तो हम लोग थोड़ा सा ऑप्शन देख के कंफ्यूज हो जाते हैं. But you just have to be focused, understand the simple logic of the question and solve it. Not too remote from his conduct. When defendant will have liability, when remoteness will be less. Remember that. Confuse नहीं होना है यहाँ पे. Remoteness of damages का मतलब क्या होता है? The more the remoteness, the less the amount of damages, the less the connectivity. Okay, so the defendant will be liable to the consequences when he is having damages and his conduct related or very much connected with each other, but not too remote from his conduct. Pointing a loaded pistol at another is a. Now this is a situation based kind of question. ऐसे भी MCQs आप expect कर सकते हैं actually, और ऐसे questions के लिए भी आपको prepared रहना चाहिए. ऐसा नहीं कि टॉट से हमेशा आपको सिर्फ theories वाले ही questions आएंगे या case laws ही आएंगे, ऐसा भी आ सकता है. Battery, false imprisonment, assault, insult and annoyance, annoyance and assault. Now कौन बहुत सारे ऐसे concepts हैं जहाँ पर IPC और टॉट्स भी आपको रिलेटेड दिखेगा. सो ऐसे टाइम पे कंफ्यूज करने के लिए आपको कुछ ऐसे ऑप्शंस भी दिए जा सकते हैं, क्वेश्चंस भी बनाए जा सकते हैं. सो पॉइंटिंग अ लोडेड पिस्टल एट अनदर इज व्हाट? इट इज असॉल्ट. Assault, very famous element of assault or ingredient of assault is that there is no physical touch involved, but the activity is so inherently dangerous that it is threatening the person. So that is what is pointing a loaded pistol at another. Damage caused to property is actionable as dash in torts. Negligence, private nuisance, defamation, dispossession and private nuisance, trespass. So damage caused to property is actionable as what in cause, that is what is the question. कौन से कैटेगरी में ये आ जाएगा? सिंपल है, प्राइवेट न्यूसेंस, बिकॉज somebody's property you are causing damage, then in torts it is प्राइवेट न्यूसेंस. एंड सारे ऑप्शंस देखकर हम ये समझ जाते हैं दैट इज इट इज प्राइवेट न्यूसेंस विच इज द करेक्ट ऑप्शन ओवर हियर. Public nuisance is punishable under which law? CRPC, criminal law, Indian Penal Code, tort law, not punishable. So whether first we should know whether there is a concept named as public nuisance or not, and if it is there then under which law it is punishable specifically. So यहाँ पर आपको बहुत सारी चीज़ें मिल गई है, बट इसमें ऐसा कोई कॉम्बिनेशन ऑप्शन तो है नहीं कि हाँ IPC भी है, टॉर्ट लॉ भी है. स्पेसिफिकली पूछा गया है, स्पेसिफिकली यू हैव टू आंसर, एंड द करेक्ट आंसर इज IPC. IPC section 268 talks about public nuisance. Now you don't get confused over here. Yes, public nuisance is recognized under law of torts, but what they have asked you over here that it is punishable under which law? That means it is an offense which is having some punishment. So which law will be that? That will be Indian Penal Code. What is the essential requirement for false imprisonment? That is what is the question. Total restraint, restraint with violence, restraint in one direction only, circular restraint. So what is the essential requirement for false imprisonment? That is what is the question. False imprisonment, first you should know what is the concept false imprisonment. False imprisonment, how it is restraining the person. That is the thing which is the logic behind this question. And the correct answer is A, total restraint. Because here when you are imprisoning somebody, you are completely restraining him. Not that you are just stopping his way in one direction, but all the directions. You are not allowing him to go anywhere. You are curtailing his liberty. So the correct answer is total restraint. Negligence is failure in duty of taking due care. So the expression duty here means what? Legal duty, legal as well as moral duty, legal as well as social duty, a specific legal duty, a specific breach of illegal duty. So negligence is failure in duty of taking care, but what is the meaning of duty over here? That is also asked. Means ये थोड़ा सा डीप में क्वेश्चन पूछा गया है यहाँ पे, बट सिंपल है. अगर हम थोड़ा लॉजिक अप्लाई करते हैं तो हम इसे भी आंसर कर सकते हैं. वी शुड बी प्रिपेयर्ड फॉर सच काइंड ऑफ क्वेश्चंस ऑल्सो. इट्स नॉट नेसेसरी दैट ऑलवेज वी विल गेट डायरेक्ट क्वेश्चंस ओनली. समटाइम्स ट्विस्टेड क्वेश्चंस कैन ऑल्सो कम. So legal duty as well as moral, social, specific legal duty, specific breach of illegal duty. So the correct answer over here is a specific legal duty. If that is breached, then that the end result will be negligence. And the famous principle res ipsa loquitur is what is important in law of torts, which is working behind the concept of negligence. Which of the following is not true about the tort of defamation? Statement is defamatory. There is an unintentional reference to the plaintiff. Right-thinking members in the society infer that the statement refers to the plaintiff. Statement is made known to other members of the society. Statement is written, published or spoken. So what is not true that has been asked to you? Please don't skip this word not. Many times this silly mistake happens with everybody. We just focus on the options, we read this and then we try to come to the conclusion, and that is where we get confused and lose marks. So it is not true has been asked over here. there is an unintentional reference to the plaintiff, ऐसा नहीं हो सकता है. In defamation there should be an intentional reference to the plaintiff. Now this UN, if you skip again, you made a silly mistake over here. ऐसा नहीं होना चाहिए. Defendant, if there is injury to the reputation of the defendant, it should be intentional. It cannot be unintentional reference. In contributory negligence, one party is negligent, another has not taken due care. Both parties have contributed to the negligence equally. Lack of care is equal on both the sides. Any one of the parties is negligent, that is resulting in injury, while the other has taken due care. More than one party has contributed to the tort of negligence, that is, there is more than one tortfeasor. Now, contributory negligence, first of all, the concept should be clear in your mind. What is the meaning of contributory negligence? If you are clear with the concept, you can very easily solve this question. Correct answer is A. One party is negligent and another has not taken due care as well. So, in this case, both have contributed to negligence over here. So, here damages will be varied. Last question for today's discussion. The Wagen-Mount case discusses what? Now this is a case law based question, but I have taken here purposely because ये case भी important है और इस तरीके से questions तो definitely आप law of torts से expect कर ही सकते हैं. What does the Wagen-Mount case discuss? Reasonable foresight, directness, defamation, negligence, remoteness of damages, test of reasonable foresight. Which topic is it related to? Remoteness of damages and test of reasonable foresight is the exact topic to which it is related. If we mark any of the option, we cannot do that. We have to be very specific over here because the options are very near to each other. So we need to know the exact case over here. And what is held that the damages, in order to calculate the damages, remoteness, test of directness was replaced with foreseeability in the Wagen-Mount case. यानी कि जो test of directness हुआ करता था उसको replace किससे किया गया है? Test of foreseeability से. So if it is foreseeable, then it is not that remote. That was held and discussed in the Wagen-Mount's case. So this was all that I had to discuss with you all. If you have any queries, you can write to us in the comment section of this video, and also you can write to us on hello@iexambee.com. So don't forget to subscribe to LegalBee. Stay tuned and prepare 50% faster with iExambee. Thank you everybody.